Welcome to the Emerging Lawyer series at the Coffee Conversation Show, powered by the Emerging India Forum, TIF, and a tech partner, Prime Infotech Solution. Theme is Oceans, Orders, and Open Dialogue. Ethelwald Mendes on Maritime Law and Mediation. A seasoned maritime litigator, a respected arbitrator, and a passionate ambassador for mediation. With over 3 decades of legal practice and international experience, including roles with ICC Paris, IMLAM Australia, and now a board member of INADR, Ethelwald has helped shape the global conversation on dispute resolution in maritime. From complex admiralty cases to championing alternative dispute resolution methods, his work reflects a rare combination of legal precision and human empathy. Join us as we dive into his incredible journey across ship decks, courtrooms, and mediation rooms and discover how one lawyer turned the tide towards peace building through dialogue. And we also understand Ethelward as a person. So, welcome, Ethelward, today's coffee conversation episode.
I would say G, but I'll do it with coffee.
Thank you, sir. So let me explain you, Tilwag. It will be divided in two parts. Sorry, three. There are three rounds. Your professional journey, personal journey, and a surprise rapid fire round where you will be in the hot seat and you have to be witty, fun, and quick. And here's inspiration, Legal AI 101, which will be autographed and sent to you.
Thank you. Thank you very much.
And
And
I'm
no
sorry.
phone a friend available?
we uh, we want to plan, but how to do that because there's some questions are related to that also, KBC format. So my let's see, we'll plan something like phone a friend and find out yeah, his views on you.
Yeah. Thank you.
Okay. Okay. So I'm planning to do a panel discussion with you, Aishwarya, अपना ये अपना वीरेन के अपना how maritime laws have evolved in India
Okay. Yeah.
and then international also. So I'll need your help in that.
Absolutely happy to help.
Okay. So let's begin. The friend, I'm Lion Amir Virani, host at Coffee Conversation, legal tech evangelist at Prime Infotech Solution, author of 15 books. We help law firms copy legal startup SMEs, world-class technology, software licensing, and tech training solutions. So, Ethelward, you have had a robust career spanning 30 years in maritime law. What first drew you to maritime law, and how has the journey been?
Okay. To start this, I started my life post college, or rather through college, by joining the Marmagaon Port Trust, which is an authority that deals with the port. And while I was there, I had the opportunity to become a trade union leader, and I was the vice president of the trade union employees spanning all over India. It's a pan India trade
Mhm.
organization, and therefore that actually working at the sea and dealing with problems of people at the sea is what was the base of my career. The minute I finished my master's in law, I left the organization to start my independent practice. And as a result, all my contacts in the port as well as the business houses gravitated towards me. And that's how my career in maritime law grew. And my love with the sea and with the ships continued to flourish. At that time, I was young. I liked traveling, and the maritime law takes you to seas and ports and countries. And most importantly, laws that you have never seen and experiences that you will always cherish. So that's basically how I started with maritime law. And the court that I was in Marmango, Vasco da Gama. That's the city. So therefore, there was a lot of history that actually brought us and grew the maritime practice. Yep. So
Wow.
that's me. And the international practice grew because Goa was a trade hub in iron ore being exported
Hmm.
to East China, Japan, and various places out of Goa. So therefore, there were various contracts in the mining industry with arbitration clauses outside India. It used to be either in Singapore, which was a friendly nation, and if you're dealing with China, it was mostly in Shanghai or in Beijing. It's only thereafter that because of the hostility that Hong Kong started developing as a preferred alternative for Indians to do arbitration out there. So that's the international flavor of my practice.
Wow. So thank you to leading me to my next question, and let's dive deep in conversation. From Goa to global forums like Paris, Australia. Now you're in at Copenhagen, and we are now having this coffee conversation. How has your geographic diversity shaped your legal lens?
See, the important thing is that in maritime law, one of the important aspects is harmonizing of international maritime laws. Because a ship moves from one jurisdiction to another jurisdiction and a lot of time in international jurisdiction. So every ship and the people on board, including the cargo, must necessarily deal and delve with at least three ju- legal jurisdictions. One from what we call the ship, shipping origin, other one is the destination origin, and in between the international origin. So therefore, it makes a lot of challenges, I would say, especially when you deal with jurisdictions whose language is not your native language or the language in which you studied.
Wow. Okay. So, Ethel, someone who's seen both litigation and mediation closely, what core differences do you believe shape outcomes in each process?
See, the litigation is a very standard process. In fact, as far as India is concerned, and probably most parts of the world, it's a niche practice. But that's the admiralty law, where most maritime disputes end up in an admiralty court because they are maritime claims. Now, as far as mediation is concerned, or the alternative dispute resolution, that falls into two parts, which is arbitration and now most modernly mediation. As far as arbitration is concerned, most of the maritime industry is tied to various, we call trade houses, whether it's the BIMCO, whether it's this. So most of these standard clauses, bills of lading or charter parties, they have their standard arbitration clauses. So therefore, those standard arbitration clauses kick in arbitration as an alternate dispute resolution. It has its own inherent difficulties as to the choice of law, the seat, the venue, and most importantly, the execution of awards that may be passed.
Wow,
In
beautiful.
litigation, when we do admiralty law, it applies when a foreign ship touches the port. And the court there then assumes jurisdiction, gives a legal persona to the ship, and arrests the vessels for the claims that may be brought into that. So these parts. So execution and dispute resolution become easier. Now, the new modern method that is coming in today is mediation. Mediation has an the benefit of it is that it allows parties to resolve the dispute themselves without getting into the nitty-gritties of jurisdiction or seat or venues. And with the Singapore Convention, execution of a settlement becomes easier. Rather, it's not execution, but the acceptance of a settlement in another jurisdiction become much more easier because of the Singapore Convention, which legitimizes that whole effort and that work. The other important aspect into mediation, as far as India is concerned, is that all maritime disputes become commercial disputes. And all commercial disputes above a certain threshold must necessarily come under the Commercial Courts Act, which has Section 12A, which makes it mandatory for mediation as pre litigation venue. So, this is the three basic challenges for both people in maritime business as well as practitioners in maritime field to understand.
Wow. So, Ethel, how do you manage the balance between being a litigator and being an empathic conciliator?
See, the there is no such thing as a balance between the two. It's a matter of what's the most appropriate. In fact, that's what the word that we use is not alternative dispute resolution, but appropriate dispute resolution. And to give you an example, that way it will best explain, because there was one dispute which is very peculiar. It's a shipping dispute. It's a vessel, new build, which had to be delivered to the client, and the dispute was over the paint that was applied to the vessel. It went through all the streams. It went to litigation because it had an arbitration clause, and the arbitration clause had to have a arbitrator who was well versed with maritime matters. That was a little vague, but maritime matters. And both parties couldn't agree on the arbitrator. So, under the Arbitration Conciliation Act, we had to go to the High Court to get an arbitrator appointed. So, litigation started. At that point, when we went to the High Court, I told the judge that, look, the quality or the qualifications for the arbitrator had to be a person well versed with maritime matters. And the judge said, so what? Don't our judges do admiralty work? So they know the admiralty, they know maritime law. What's your problem? I said, he says, nothing doing. I'm not going to listen to you. Are you interested in arbitration or not? I said, I'm not opposing arbitration. So an arbitrator got appointed, a retired judge. So we went to arbitration. When he went to arbitration, the arbitrator is an old judge who knows me otherwise also into practice. And he says, Mr. Mendes, why are you having a difficulty to resolve this matter? This matter is about a payment of a bill. The painter has applied the paint, agreed that the paint that was stipulated in the contract was not the one that was used. But admittedly, that was not available in the market. You wanted your vessel fast. So he applied the next best paint. And in order to give it the right shine and the gloss, he applied an extra coat also. Instead of 2 coats, he's applied 3 coats. But he's not billing you for the third coat. So you've got extra paint up for you free of cost. So what's the difficulty? So I had to explain to the judge, Your Honor, the paint that was contracted has got a heat signature. So he says, so? I said, but the vessel requires, depending upon where it's going to apply, a peculiar heat signature. If the heat signature is not correct, the algae formation takes place faster. So I could see that the judge was now getting out of his depth. Then I told him that the third coat that was applied has increased the weight of the vessel, so the gross tonnage has gone out. As a result, the displacement is higher, so the load of cargo that can be taken on board is reduced, and the amount of fuel to be used is also gone up, and the propulsion thrust is also reduced. So the judge said, I think all this has gone above my head. And he asked me, how do you understand all this? And I had to tell him, that's because I'm a director on a shipyard and therefore I come from a background. Then the
Mhm.
lawyer told me the other side. He says, I think, Mr. Mendes, we are not going to be able to do anything in this arbitration. And I told him, I said, that's exactly what I was telling you, that why don't we agree to getting a surveyor, a maritime surveyor to be appointed as an arbitrator and decide what we are required to do. And ultimately, the matter went into mediation, and that matter got resolved through mediation. So therefore, this is the difference between litigation, arbitration, and mediation.
Wow, beautiful. Okay. So, Ethelwald, what challenge do you see in building a stronger culture of mediation in India for maritime cases?
Unfortunately, there are two hurdles. One is the lawyer themselves. It's not that the lawyer is opposed to mediation, but the lawyer discounts mediation because he doesn't understand it properly. For most people, the concept of mediation means a bargain or a compromise. So,
Hmm.
therefore, the incidence that I have to give up something is what frightens them. Two,
Hmm.
the lawyer has done 5 years of studies in college and a few years thereafter with some senior as an understudy and thereafter as an apprentice and then a junior lawyer and then he comes through. In all that study, he has never studied mediation. So he does not know what to do. The other aspect for the business house, he says, look, I'm doing business. This is a dispute. In the traditional method, here are my files, here are my papers, here's my check. Now go ahead and get me the results. In mediation, we tell them, look, you are the author of the dispute. You are also
Hmm.
the solver of the dispute. So
Wow.
they also do not understand the nuances of what to do in a dispute. These two disconnects often cause the bottleneck where they can use mediation to actually resolve their disputes, which they actually do day in and day out without realizing.
Wow. So, Ketan, what have been the most significant shifts in international arbitration and maritime laws over the last 2 decades?
See, what has happened is, if you will, let's look at Singapore, which was the main arbitration hub, and we call
Hmm.
the SIAC, which was an alternative to the ICC and LCIA in London. But the SIAC is the general arbitration. There was a sister concern that was known as the Singapore International Maritime Arbitration, which was
Mhm.
considered as the younger sister, never growing. But today, as the world commerce grows, people have realized that even in arbitration, you require a specialist, both
Yeah.
in the knowledge and in the handling. So, therefore, the maritime alternative or the best appropriate method has moved from arbitration and with the Singapore Convention now being available to mediation as a dispute resolution mechanism. And the best thing about mediation is it does not have issues of applicable laws, it does not have issues of jurisdiction, it does not have issues of judges not knowing the subject and not knowing how to deal with the matter, because the matters get resolved by the parties themselves and a neutral mediator who only facilitates the dialogue.
Wow. Okay. Let's go maybe down the lane, Ethelwald. Can you share an instance where mediation proved to be more impactful than a courtroom verdict?
And I'll share this with you or a matter that took place in Beijing. It's an international arbitration there. Also, something like this. The contract was drafted in Goa. It's a maritime contract dealing with ore and parties sitting down in Goa. They are talking in English. They're negotiating sale of ore from Goa to China. The contract is drawn up in English, and they are all very happy. The Chinese say, look, in case of a dispute, we want an arbitration before CTAC Beijing. CTAC is the arbitration institution in Beijing. And the Indians say, okay, fine, we trust in God, we don't think anything will go wrong. So what? Beijing, Beijing. Okay. The arbitration clause is agreed and it's done. Ultimately, there is a dispute over the quality of the ore and the volume of the ore that is loaded, because ore, when it is shipped, has got a little bit of moisture, and in the traveling it may gain or lose, and thereby the discharge port volume gets reduced by the moisture added or lost. So that
Mhm.
causes a dispute. So in that dispute that was there, the dispute took place before CTAC, statement of claims were filed, and then came at that time, the law had not changed in China, that if the contract did not have the language of arbitration, then the default language is Chinese. So now the party says, oh my God, we never thought about it, but it's okay, we'll get a translator. So we had a translator, we went to Beijing, we went to the CTAC office, and they said, sorry, not your translator, but the approved list of translators. So we had to get now a translator from the approved list. So that was there. A girl was assigned to me. And the first sitting went on okay. The second sitting, when we had an issue where we were to decide whether it's going to be a documents only and acceptance of the documents that were produced by the parties, they said something to the girl translator. She started crying and she ran away. So one of
Hmm.
the arbitrator was a panel of three arbitrators. So they told me, one of the chaps, he says, "Look, your translator is gone. So what will you do?" I said, "I don't know. You said something to her. She started crying. She went away." So he says, "Don't worry. I know little English. I will help you." I said, "It's okay." So fine, they talked in Chinese amongst themselves. And then they wrote out the request and they said, in the Roznama of the date, that is the documentation of the day, they wrote my name in English and the next date in English. And the three of them, arbitrators and the other side lawyers and the parties, signed. And then they handed it over to me. So immediately I took it and I wrote my name and the date is in English and I signed. So then the arbiter tribunal turned to me and said, "Look, what is this that you are doing?" I said, "Anything wrong? My name and the date is in English. That's it." So they went into a huddle, and then one of the chaps who knows a little English, he comes back and he says to me, "Look, Mr. Mendes, if this record is shown, wouldn't the execution be difficult because there is lack of hearing since it's in a language that it's not known to you?" I said, "Yes." So they went into a huddle. They said, "Okay, fine, there's the next date. Let's go back." So immediately I came down. I told my client, who was down there with his translator, I said, "Take me straight to the airport." He says, "Why? What happened?" I said, "I'm on a tourist visa." See, this is another problem when you for a dispute resolution, that when you go there, the other side is definitely not going to give you a visa. So,
Hmm.
and you're not doing business out there. So you end up taking an inappropriate visa. So I told him straight away, "Take me to the airport." He says, I said, "Here is my key. You go to the hotel room, check me out and send my luggage to Hong Kong." When I reached Hong Kong, because that's more neutral,
Hmm.
they contacted me and they said, "Where are you?" I said, "I'm already in Hong Kong." So he says, that's difficult. Now, how do we resolve it? I said, "By talking, by negotiating, and by mediation." And we resolved the dispute because I was in a neutral country out of their reach
Yeah.
in this conflict
Oh,
by mediation.
wow. Beautiful example. Ah, okay. Let's continue the conversation.
Yeah.
So, how has experience at ILAM helped in your work as
INLAM.
American
That's International
LAM?
Maritime Arbitration Rule. Now, that's a mood for students. And the quality that you see there of the students
Mhm.
is super high. They actually are trained by many maritime lawyers themselves. The students go there. And
Ah,
the arbitrators who are assessors are seasoned maritime arbitrators. So you get to learn from the other arbitrators the disputes. You get to see the students how they end up in a mock arbitration. You get to see the various jurisdiction of applicable laws. And one of the most important aspects of that is the universal Hague-Visby rules. The disputes are built around that. So you so for an Indian who has very little scope to learn maritime law in an institution, these become a great learning opportunity.
wow. Wow. So, Ethelwald, you're now a board member of INADR. What's the full form,
Yeah.
please tell us?
It's
Let me complete.
international, yeah, it's International Arbitration and Dispute Resolution,
Wow.
INADR. It's a
INADR.
Chicago based organization that helps students worldwide to get to know about alternative dispute resolution, especially in the field of negotiation and mediation.
Wow.
And I am the only Asian on that board.
Wow. That's impressive. Okay. So, I'm touch wood through coffee. I've learned about ADR, ODR. This week, I had coffee with a young co-founder, Namita Shah of Presolve 360. That's an ODR
Okay.
platform
I
for
know she knows me well. She's a young student. who's passed through my
Yeah,
hands years back.
she's doing good, Ethelwald, and
Yeah.
uh, the the platform and impact she's bringing, she's helping, she's part of apna other initiatives, mentoring ye women out there, and
Mm.
apna ye, uh, uh, what do you say, doing good work, and so learned a lot from her, and it was impressive conversation, interesting, engaging. Okay, so now apna as you said कि भाई you know Namita, so now how do you mentor young ये lawyers who enter the world of maritime law in India and internationally?
See, one of the things in India, the scope, like I said, the maritime practice is a niche practice.
Yes.
It's a practice that's not open to many people. You have to have serious love for maritime law and be able to get the scope to enter there, that door. So you have to be lucky to find the key, and that key will then open the door of the maritime world to you. Since it's a, like I said, keep repeating, niche practice. So therefore, the roads to that are few.
Hmm.
Now, one of the best ways to do it for students or young lawyers is to get involved in the maritime moots that take place, because there you come in contact with the various maritime professionals outside of court, wherein those professionals are ready and willing to take youngsters under their arm. They are ready to help them, they are ready to answer questions, they are ready to guide them. In court, if you go, they are busy with their own briefs, they don't have time for you. If you are an intern with them, then there is no question, you are there with them, you are learning a little bit within them. The other lawyer looks at you as a hostile person, the enemy from the other territory. But the moots, there are no enemies. It's a learning environment for everyone. So therefore, that's one of the things that I always tell students: look to the moots. They are the new window of learning.
Wow. So, Ethelwald, how is legal education, especially related to maritime laws, ये evolved or ये in India?
See, in India, unfortunately, though we have a large maritime coastline, we have a large maritime history of seafarers, but they are all on the technical side. On the legal side, Gujarat has been a pioneer state that has started a full course on maritime law. There
Mhm.
used to be one in Uthandi, Chennai, under the Ministry of Ports, but today the legal wing of that institute has shut down, and only the technical wing is there. There is in Odisha, the National Law Institute conducts a maritime law arbitration moot competition. So they have a few lectures that are only as optional lectures available to the students. In Goa, there is one college on which I am on the governing board, which is also doing at the masters a few subjects on maritime law.
Mhm.
Naroji Institute of Maritime Studies from Mumbai used to conduct some sort of certificate courses, but I think over the last 10 years or so, they have now stopped it. I don't understand why, but a large number of industry were really wanting to do that. So today, if students want to do a full-fledged course, they either move off to England, Southampton, or to Queen's Mary, or they go down to Malta, which are the traditional places to learn maritime law.
So sad. Okay. Uh, so, Ethel, how have maritime laws evolved over the years in India? And recently, three maritime laws got enacted. So, what are your views on that?
In fact, you are like a bolt out of the blue sea. The speed, because it's not even 48 hours since the three very, very important laws were cleared by Parliament. Now,
Yeah.
in those three laws, the three most important laws are, and let me get you into this, is the first one is the Merchant Shipping Bill of 2025, which replaces an over 50-year-old law, the Carriage of Goods by Sea Bill 2025, which replaces a 100-year-old law, and the Coastal Shipping Act, which is an act that replaces the Inland Waterways Act. Now, all these three laws are modernized. They are taking into account the fact that India wants to be a vibrant maritime industry. It removes a number of clearances. As far as the carriage of goods law, it's built around the Hague-Visby and the three protocols that followed thereafter, that allows for a greater transparency and for a greater efficiency in dispute resolution mechanism also. So the three laws that are there, hopefully they will soon become acts when the president provides the assent to it, and we will then have a requirement which most practitioners have found wanting. And the peculiar thing is that the Indian maritime law, which was built around the Admiralty Act, all gravitated to a very famous judgment, what was known as the Sea Princess Act, in which both sides found ample resources in that one judgment. Today, the law now takes out that ambiguity.
Wow, impressive. So let's look forward to 2025 establishing the seeds, maritime lawyers, and what do you say? Colleges set up maritime courses for law students to take up this niche area of law. And with this three laws being enacted, and we don't have to go to foreign countries to study and come back to India. So with this forum, I'm just hoping there will be in 2025 or 26 new, what do you say, colleges out there start maritime courses.
Yes, I would say
Well
colleges
established.
provide a greater hope for India students on Indian shores.
Yes, we have got a rich maritime coastline. So we have to, technical side is well established. Now we have to cover the legal education
Legal
side.
side, which was
Yeah,
lacking for quite some time.
yeah. Okay. So let's go to the next round and understand Ethelwald as a person. Tell us about your family and your formative years in Goa.
Okay. My father also worked in the port, so therefore we are around there. Uh, my mother, both of them have passed away. My brother used to live in Canada; he's passed away too. But I have a, I have two kids. My wife was also working in the port. All of us have passed out from the law college, so we are all familiar with the law. My daughter is in Copenhagen. That's why I'm in Copenhagen. And she works with Merck's Oil. So therefore, it's the sea. My son works with ABB in international
Oh.
arbitration with a whole host of cross-cultural, cross-border disputes. So we are
Hmm.
unpleasant committees when it comes down to family functions because we always talk the law.
And maritime.
Yes.
Wow, interesting, interesting.
Yeah.
Okay, so what are your memories of being in apna Goa?
Goa is a place of great sunshine. It's a lot of place of hope. People come there. And hopefully, we've always been cherishing the requirement that Goa will become a good hub for international dispute resolution. That's my cherished dream, that we can make Goa not just a destination place for relaxing and enjoying, but also do some work on the side.
Yeah, we hope. So, what role has faith or spirituality played in your approach to conflict resolution?
I'm quite a spiritual guy, or rather, I believe that destiny, God, plays a very important role in everybody's life. And to me, that faith matters. It doesn't matter which faith you believe in, so long as you believe in a God, because that is, like you can say, the North Star that guides the ship on the
Yes.
sea.
Wow. So, what's your go-to destination when you need to disconnect and reset?
I don't think so. There are very few countries that I've not visited, but the country
Yes.
that I love most is I love Hong Kong. Hong Kong is a great territory, but unfortunately, it has a discriminatory entry regime towards Indians,
Oh.
because Indians and Taiwanese are the only countries that require a pre-arrival registration to enter Hong Kong. And this is a note of caution that I tell my business houses when we take Hong Kong as a venue or a seat for dispute resolution. Because if you don't get your visa clearance, that is the PAR, pre-arrival registration, you can't enter Hong Kong, and you're
Oh,
at a
wow.
disadvantage. And
Mhm.
it's it's based on an algorithm that's computer controlled without human intervention. So if your computer rejects your PAR, there's no other way you can get an entry excepting if some firm from Hong Kong works and gets you that entry there, a visa from inside Hong Kong. So that's one of the greatest problems that you enter there. Another place is, of course, Thailand and Bangkok in particular, not from what all Indians look to that. Most people don't understand that Bangkok is a great seat of business. A large amount of business that they do, whether it's computer or heavy automobile industry, all originates from Thailand. And more so because I have a bias to it, since I am one of the international consultants to the Thailand Arbitration Center.
Wow. Okay. Uh, is there a favorite book or film that has influenced your personal philosophy?
Of course, the Bible for us, because I'm Catholic and Christian, that is true. But otherwise, from mediation, uh, Getting to Yes by William Fisher at Uri is the one that most mediation experts as their kindergarten book to learn mediation. And from India, a book by Sri Ram Panchu, a senior counsel from Chennai, a man of
Mhm.
great astute and wisdom, has written a beautiful book on mediation, which Indian and international students should get their hands on.
Wow. That's interesting. So, Ethelwald, if your life had a soundtrack, what three songs would definitely be in it?
Songs from Jim Reeves, One Day at a Time, that one. Then I would like, of course, Elvis Presley. I'm an old guy. Jailhouse Rock. As a lawyer, jailhouse is where we started getting our money from, getting people out of jail. But it's a great vibe that gets through. And of
Mhm.
course, from the modern era, Brian Adams. Yeah.
Wow. So, my last two questions are reflective. What legacy would you like to leave behind?
The legacy that I would like to leave behind is that Goa becomes a vibrant dispute resolution center. That people
Beautiful.
come to Goa with an idea that it's not only to let your hair down, but also to let your hair up.
Hmm. Wow, beautiful. So, my last one is a googly one. Describe Ethelwald in one line.
Okay. I am serious, but being a Gemini, I'm also vibrant.
Beautiful. Let's put you in the hot seat and enjoy this rapid fire round. Uh, your go-to comfort food.
Would be, I really don't see a go to comfort food, but definitely I'm diabetic, so my sin is chocolate.
Okay, fine. Mediation or moot court?
Both. You learn mediation via the moot courts.
Yeah. Paris, Brisbane, Goa, or what do you say? Hong Kong. Pick one to live in forever.
Oh,
Wow. Favorite maritime legal drama or movie?
uh, 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 oh, the Titanic. It has everything to it. It has
Yeah.
drama, it has ship, and of late, it even in the souls, it has a controversy that it was not the Titanic that went, but a sister ship. So it still never dies.
Yes, I know. Okay. Classical music or courtroom silence?
Classical music,
Wow.
definitely.
One word your friends would use to describe you.
Oh, great guy. I hope so. They do that.
Yeah. I'll start this KBC style dialogue. Legal legacy you admire the most.
uh, i i I started my life knowing. Uh, in fact, one of the person that I really admire most is my senior. That he wasn't my senior, but with whom I worked is Mr. Harish Jaktiani.
Wow.
He
Beautiful.
is a great guy, a good friend, and a great mentor too to many
Yes.
people.
Wow. So, my last one, tea or coffee to recharge?
Coffee. Oh man, I'm a coffee nut.
Yeah, you're the coffee show.
Yes,
When
I'm
we
a
meet
coffee
in,
nut.
we'll meet in Goa, and I'll give you this autographed cup.
Thank you very much. Yeah.
So, friends, and to Ethelwald, this has truly been an inspiring deep dive. Your journey across oceans, courtrooms, and mediation rooms shows us all what it means to lead with wisdom and empathy. So, we thank you for bringing such clarity, humility, and vision to this dialogue. We hope our audience takes away not just lessons in law, but also in humanity from your story. To everyone watching, stay tuned for more transformative conversations right here at the Coffee Corner Show, as there are 500 plus coffee speakers sharing their professional, personal journey. So don't forget to subscribe and join us as we continue to spotlight thought leaders who redefine what it means to emerge, evolve, and excel in the legal and different areas of actions. Until next time, keep the dialogue open and the ambition high. So we meet with another coffee speaker or a cup of coffee, continuing conversations. So take care. Thank you.
I, Captain Virani.
Thank you.